we can play that by ear as we go. So we can maybe just give an indication when we're formally going live, and I'll do formal introductions.
Yep, we're streaming now.
Okay, thank you. Good morning, ladies and gentlemen, and welcome to the pre-inquiry meeting in relation to the Berwick Bank Wind Farm Onshore Compulsory Purchase Order 2023 and objections to that. My name is Paul Coquette. I'm a reporter appointed by Scottish Minister to report in relation to the CPO and the objections, and this pre-examination meeting is being held further to the relevant notice letter issued by me on 1st June under the relevant rules, and this meeting and the oral procedure that will follow is to proceed under the compulsory purchase by public authorities inquiry procedures rule of 1998. I'll ask parties to introduce themselves formally just in a moment, but I just want to say a couple of things at the very outset. First of all, as you know, this meeting has been recorded and is open to be viewed live as we're speaking, but it's also going to be available for future access if anybody wishes to consult it later on if needs be. And so accordingly, participation in this meeting as a recorded meeting is being taken as consent for the purposes of data protection and GDPR purposes. And also remind parties that this is a procedural meeting under the 1998 rules. We'll deal with issues of oral and the oral procedure that will follow, and it's not my intention to seek any indications as far as detailed evidence or the like that will be dealt with in later procedures. But I would perhaps welcome, starting with the agents for the acquiring authority, if I could just take a note of who's all here representing which interests for today, according to my noted list of objections. And it'd be useful, I think, if parties could indicate at this stage if they're a statutory objector as a landowner or another form, or whether they are in neither of those categories and therefore non-statutory objector. And I'll start with Mr. Hamilton for the acquiring authority.
Good morning, sir. My name is Colin Hamilton and I appear for the acquiring authority. Marcus Mackay, KC, and Nicholas McAndrew, advocate, are instructed for the acquiring authority, but unfortunately are unavailable this morning. Also in the room with me, but not speaking today, beginning from my right, are Nadia White, solicitor with Gillespie McAndrew, Connor Manning, the engineering manager for the project, Alex Meredith, the Berwick Bank Wind Farm Project Director, Sophie Dixon, Consents Manager, Sarah Edwards, Consents Team Manager, John Hillis from Blackhall and Powys, who are the land agents to the acquiring authority, Kirsten Grant, also of Blackhall and Powys, Victoria Porter, who's the land manager for the acquiring authority. And on the left is Emily Wallace, solicitor with SSE Legal.
Okay, thank you. Obviously,
So I think
just going on mute there. I was saying thank you for that. I would anticipate, Colin, that most of the participation this morning would be by you on behalf of the acquiring authority, but feel free at any appropriate time to bring in anybody else who's in attendance this morning if they may happen to be best placed to answer any other questions on your behalf. I've also got a note, and I'm just going to go through my list because it might be easier to do that rather than trying to identify from names and pictures on screen. I've got DDM Agriculture on behalf of Louise, David, Dorothy and William Muffet. So can I just check if they're here?
Yes, good morning. Giles Johnston, land agent representing those four Muffet family members.
Okay, that's fine. you are at least partly representing them in terms of landowners at the various sites. It'd be useful to me, maybe not even necessarily just now, but at some point, if you could just confirm. I think for most of the objections, it's reasonably clear to me what they relate to, but I don't think I was necessarily clear as to which plots these various objections relate to. I don't think you need to narrate those just now, but if you just confirm or direct me to the relevant documents that can confirm that in due course. But aside, thank you. Thank you for that. Next on my list is NNG offshore. I think it was at least one of the groups represented by Shep and Wedderburn.
Good morning, sir. My name is Scott McCallum. I'm a solicitor, Shep and Wedderburn solicitors, here today for Norton Greer Offshore Wind Limited. I'm joined, sir, on my right by Mr. David Sweeney, who is Development Manager for Norton Greer. And on my left is Mr. George Bruce, who is a trainee solicitor with Shep and Wedderburn. Sir, Norton Greer Offshore Wind Limited are a licence holder under Section 6 of the Electricity Act. So they are an electricity statutory undertaker. And they have a series of long leases and cable infrastructure within a number of plots floated by the compulsory purchase order. And they are plots 14A, 14B, 14C, 16A, and 15B, sir. I should note that 15B was not directly named within our objection letter, sir, but it's an opposite side of the road to 14C, and the same concerns and objections apply to that one. On the basis of the long lease, sir, we are therefore statutory objectors in the process.
Okay, thank you. And thank particularly for confirmation about 15B, because I had a note of the plots, but obviously not that one, so I've added that to my list. Okay, thank you for that. Next on my list, I've got Bell Rural, representing Crichton and Taylor. Anybody to speak for them? We found that no one's chipping up at this stage. They may join us a little bit later on. I've got Lindsay's representing George and Brian Ainsley and the firm of GA and BB Ainsley.
Yeah, good morning. Lewis Crofts, Associate Solicitor at Lindsay's LLP. Yes, we're representing George and Brian Ainsley and their farming partnership. They're the proprietors of plot 27A, so they'll be statutory objectors.
Okay, thank you. I didn't just quite catch your second name. Croft, did you say?
Crofts, yeah, CROFTS, yeah.
Thank you. Okay, thanks for that. And next on my list is Network Rail. Sound as if they're present today. Next on my list, Nuclear Liabilities Fund. I know that's Fraser Mitchell, because we didn't tell you about this meeting, but you're here.
Yes. Good morning, sir. I'll repeat my introduction then. I'm Fraser Mitchell. I'm a solicitor and partner at Shep and Wedderburn. As you've said, I appear on behalf of the Nuclear Liabilities Fund Limited. In terms of their status, they have a range of interests in the operation, defueling and decommissioning of Torness Power Station, all of which are secured by way of both fixed and floating charge, which has been granted in their favour by EDF Nuclear Generation Limited, the current operators. And so with that in mind, we are a non-statutory objector, sir.
Thank you. Okay, and now I've got Turk and Connell representing William Dunlop.
Good morning, sir. My name is Maurice O'Carroll. I'm an advocate. I'm representing the partners and trustees of the firm William Dunlop, both as a firm and as individuals. The holdings that they have which are affected are set out, which are numerous, so I'm not going to repeat them just now.
Yes, no, there's no need to.
They are set out in the letter of objection dated 20th of April 2023. I'm instructed by Turk and Cornwall, as you say, instructing solicitors Louise Johnson, and she is on the call today, along with Kirsten Campbell, Guyon, the trainee.
Yeah, I see a lengthy list of plots involved, so I think we can take that as read from the objection letter. Thank you. Next, I've got SPD and SPT, which is Shepherd and Wedderburn again.
Thanks, Lena McLean, partner at Shepherd and Wedderburn, representing SP transmission and SP distribution. And I am instructed today by Mr. Mark Peebles and Ms. Zoe Rocks. SP transmission and SP distribution both have a number of land interests within the order land, and are therefore a statutory undertaker in terms of Section 6 of the Electricity Act, and are a statutory objector to the order.
Okay, thank you. I didn't quite catch your surname there.
It's McLean.
McLean, thank you. Next up, we've got Tarmac Cement and Lime Limited, and that's Davidson and Robertson.
Morning. Sorry, David.
I would say Davidson Robertson, but I'm actually my hand straight over to CMS. So it's Ian Austin, Davidson Robertson here, land agent acting for Tarmac Cement and Lime, but I'll hand over to Alana Barker at CMS.
Okay, thank you.
Good morning, Alana Barker here, Associate CMS. So yeah, acting on behalf of Tarmac Cement and Lime Limited, who are also a statutory objector. Also in attendance is David Cowan of Tarmac and Ian Austin of Davidson and Robertson.
And I've also got Harper McLeod for William and Donna Christensen.
Yes, good morning, sir. My name is Davidson. I'm a solicitor and partner at Harper McLeod, and I'm instructed by William and Donna, and they are owners of plot A.
JT, that's fine. Thank you. And I've identified already also Kevin Jimison, who's also on the call, and I've noted his attendance as a resident in our who I've agreed should be permitted to participate in this hearing or this meeting rather, and there's a request by him to be effectively a late objector to the order, and we'll deal with that just a little bit later in the meeting. He will be a non-statutory objector because he's not a landowner, immediately affected. And for Mr. Jimison's sake, I know he's a statement he would like to read out, and I'm going to permit him to do that. And I'll deal with that when we get to item 3 on the agenda. So, assuming I've not missed anybody, if anybody has been missed, please shout out.
Sir.
Yes.
It's Alistair Burnett, KC here, instructed by Abrahams of CMS.
Yes.
It's on behalf of EDF Energy Limited, who are the owners and operators of Torness Nuclear Power Station and owners of land affected by the order, and therefore statutory objectors as well.
Beg your pardon. Your CMS. Okay, sorry, Alistair. Thank you. Should stress it's quite difficult to juggle all the various interests and people with the majority having legal representation. There's a lot of participants to work around the meeting, and certainly for Mr. Jimison and other people's sakes, what I'm keen to do is ensure that we keep the discussion this morning as relaxed and informal and as respectful as we can in the circumstances. I'm hoping that anybody and everybody who wishes to have a say and make their point are able to do so. There's inevitably quite a high level of formality in these discussions, but obviously it would help for those who are less familiar with these sort of circumstances to be given an opportunity to fully feel that they can participate and have their voices heard. Also, just an introductory comment. I'm grateful to the acquiring authority for confirming the notification given. I think there's one plot 10A where the owner is unknown, and I think steps have been taken to give notice of this meeting, and confirmation of that has been received. So I'm grateful for that. My intention is to prepare a draft note of this meeting, setting out the various points arising and action points arising from that, and I will circulate that for comments as to accuracy, and in particular to make sure I've noted all your names correctly just as soon as I can. That document and all others are relevant to this order, and the objections will be uploaded to the DPA website as the documents have been thus far, and the reference, as I think all of you know, for searching under is reference CPO-210-2. It will come perhaps a little bit later into discussion, but parties will have noticed also that I've asked that a report on a compulsory purchase order, a crystal rig, reference CPO-210-1, which actually one of the objectors here was involved in the motion of that NNG, and that's on the website as well, and it's uploaded in relation to some of the issues that we may discuss this morning and in more detail later. But I wanted just to alert and remind parties, simply because it's a report with which I have some familiarity. So I wanted just to say that to parties from the outset, that that's something that I'm aware of. An agenda was circulated last Wednesday, suggesting a structure for today's discussion. There've been no suggestions of any amendments or modifications to that. My intention is to bring item 11, which is the item related to prematurity and interrelationship with other matters, and deal with that after item 3. That might tie in with what Mr. Jimison will say, I think, in a few moments. But it may end up that we're better to look at that issue before we then move on to more detailed questions about the kind of dates of the of next oral process or procedure. But other than that, the agenda is as circulated. So I'd stop at this point just to ask whether any party want to make any further comment either on the agenda or anything in relation to what I've said by way of introductory comments just now that they wish to draw to my attention or raise. And I think if you just indicate coming to the call or indicate through the chat bar or whatever, or raise your hand. I can't necessarily see everybody on screen, but please shout out. And I'll maybe start with the acquiring authority, whether there's anything or indeed anything they want to say by way of a kind of an opening before we get into opening comments before we get into the agenda.
No, thank you, sir.
Okay. Right, in that case, we'll move on to the agenda. And I think effectively item 1 has been largely dealt with, I think, through the introductions that we've done in the start of this meeting. The only thing I would add to that is I know the acquiring authority have indicated that they have a desire, they have already issued responses in relation to the objections received thus far and indicated an intention to keep working with parties in relation to the identification of any common ground. But I don't know whether Mr. Hamilton, you want to say anything more about that general aspiration or anything further you want to say? Obviously, not in relation to the detail of your response to the objections, which I think would be to 30th May, but just whether you want to say anything further about the kind of future workings as we move towards the oral procedure that we're here to set the time frame for.
Thank you, sir. It is the acquiring authority's intention to continue to work with all parties towards a voluntary agreement where possible. And certainly there have been discussions, as you would imagine, in lead up to this, and good progress has been made. And it is hoped that a number of objectors will be able to remove their objection, but at present, that is not the position. All objectors do maintain their position as far as the acquiring authority understand.
Thank you. I don't know if anybody else wants to comment anything at this stage, or whether we can just press on those other aspects of the agenda. Not giving any indication for that there. Item 2, and that's just, as I said a moment ago, thank you for confirmation about the steps taken in relation to the site where the owner is unknown. I may ask the applicants to give similar notice to posting something for the oral procedure when it comes to it. I wasn't particularly inclined, we'll talk in detail later on about the site visit, I wasn't particularly inclined to ask that a notice be given in relation to the site visit, not least because if the owner is unknown, they obviously won't be there to be ensuring that we get access to their land, etc. And I hope that makes sense. But again, when we come to a bit nearer to the oral procedure, I may ask I will ask the acquiring authority to take similar steps to make sure we can be absolutely certain that for the unknown owner of the plot, all steps are duly taken to ensure they have notice as to what the consequences of the order, if approved, is for them. Item 3 on the agenda is kind of next steps in terms of statements of case by parties. Now, I'm going to open for comment in case anyone takes a different view on this. From my perspective, obviously, I've seen the acquiring authority statement of reasons. I've seen the objections that are stated thus far, and I've seen that on 30th May, the acquiring authority has written out to all the parties with an initial response, and obviously there's further communication, as Mr. Hamilton has said, that will go forward. I, for my part, feel reasonably clear as to what the basic arguments are. I've read the statement of reasons. I've read the letters of objection. I'm not particularly, for my part, and with a couple of exceptions I'll come to in a second, for my part, I'm not particularly concerned to be asking people to be lodging further statements or clarifications of statements of their position, unless their positions happen to change. And obviously, to do that, that's a bit different. The two exceptions, I guess, one of which I know that Tarmac Cement had reserved their right to submit further statements, and I don't know if they want to comment on whether that's going to be forthcoming or whether that's been superseded by events.
Yeah, I think discussions are ongoing at the minute with SSE, but I think they would still want to reserve that right to potentially submit a further statement.
I mean, parties will obviously all reserve their rights to make further representations as they think fit. But simply in terms of looking at this stage and the ability to identify what the general heads of objection are and the grounds for objection, unless anybody has any particular specific thing they want to say that might change something going forward, I feel I'm reasonably clear as to what the broad grounds of objection are. The detail of this obviously will address in oral procedures. And I'd be quite keen to reach a stage where we're at least sufficiently clear that there's no suggestion of kind of brand new arguments coming up. I'm hopeful that people are going to be content to rest on the arguments, the objections they've put so far, just for the sake of clarity at this point. But I'll maybe, again, starting with the acquiring authority, just invite them to comment and then open up to others in case they take a different view in terms of sort of, if you like, broad outlines and, if you like, intimation, fair intimation to all involved as to what the cases might be. So Mr. Hamilton first.
Thank you, sir. Without wishing to jump ahead to item 11 on update on the consents, I should note here that the acquiring authority does anticipate that it will lodge additional environmental information in relation to the onshore application and offshore applications, and that's anticipated to take place in mid to late July. Now, it's not anticipated that any of that information will result in a change to the order or any significant change to the onshore works. But it is, of course, possible objectors will want to consider that material in preparing what they have to say. And I can say more about that later if required. I would agree with you, sir, that the Acquiring Authority does understand the basic points to be made. And there are some areas of detail, though, I think could do with further clarification. And again, it's a further agenda item, but those are in relation to alternative sites.
Yeah.
The Dunlops have indicated they would like more time to prepare their case. And in addition to Tarmac, I have noted that a number of other parties, I won't name them all, had reserved their right to make further points in their letters of objection. So while I'm entirely in your hands, it might be that suggesting statements of case are lodged by, say, 28th August, just to shape what the final position of parties is in relation to their main points, 28th July, beg your pardon, would be appropriate. And then to have a further pre-inquiry meeting in mid-August.
Okay, thank you. I just open up that to others. If anybody wants to comment on that suggestion. Mr. Carroll? Oh, I think you're still on mute just now.
Sorry, that's my one time of not doing the mute. Okay.
We'll do it at least once, so get it out of the way.
That's my one go. I think from what I read from your own correspondence, sir, is that you're minded to treat the letters of objection as standing in the place of statements of case. And that is something that I'm content with. I think that's a very expeditious way forward. It seems to me that requiring a further statement of case and further procedural step is simply going to duplicate what's already been done, perhaps unnecessarily encumbering this inquiry. So on the part of the Dunlops, having taken instructions, I'm content to rest on the letter of objection dated 20th of April 2023. Thank you.
Okay, any comments from others? Peter? You're also doing your one attempt. Yeah. One strike. I've done it as well. So
another 50 pence in the jar. My clients are broadly content to rely on the objection as I said. There is one point arising from the acquiring authorities on the objection, which I do need to clarify, and depending on the nature of that clarification, may lead into another enhanced round of objection. But I can either outline that clarification very briefly now, or I can do that in correspondence, whichever you have.
A brief indication just now would be useful if you keep it brief.
Of course, yes. The nature of the rights in relation to plot 28A are drainage rights, and the response to the objection pointed me in the direction of paragraph 9 of part 1 of the schedule for the order, and that refers to the rights benefiting the benefited property as it currently stands and potential future divisions. It's the subdivisions element I'm looking for clarification on. If that simply relates to internal arrangement by the acquiring authority for its own purposes, then that's one thing. If it relates to those rights potentially being passed to sub-parties, that's what I'm looking to clarify.
Okay, thank you. Anybody else? Okay, I'm not seeing anybody chipping in just now. My one slight reservation about 28th July deadline for further statements of case. I mean, accepting that all of you, and I recognise for all of you, anything further that may come or elaboration of existing grounds, that's obviously completely within the scope of what I have in mind. If the acquiring authority are going to be producing in the next few weeks further information that might require comment on 28th of July, and I'm acutely conscious of holiday periods coming up, putting a deadline for kind of formalising a statement of case for 28th July might end up being quite a an onerous task in the event anything further coming from the acquiring authority might be extensive. I'm probably inclined to say, let's see what they come up with by way of the further information that Mr. Hamilton has alluded to, and then parties can then consider the impact on their respective objections. It might be easier, in fact, in Peter Ferguson's example, that there might be some sense once he's considered those issues, him drawing something else together in one collective document, and it's ease of paper management as much as anything else. I'd be inclined slightly to reserve judgment to see what the acquiring authority come up with, and allow parties to think and reflect of what that means for them, whether they can then deal with that by simply part of the iterative dialogue that goes on between parties, or whether that's something that, for the sake of good record keeping, might require a statement of case. So I think I'll probably reserve judgment until we see what further comes in, maybe around the end of 28th of July. I would not rule out the possibility of us having another pre-inquiry meeting, certainly at some point in August or whenever. But I'm probably inclined not to fix a date for statements of case just now. But obviously, the sooner the acquiring authority are able to come up with further information in that respect, that can allow us to make a judgment as to ways forward in that respect. I want to now bring in Mr. Jimison, who had contacted me, contacted my office after the period for objections to the order had expired, but he had done so reasonably soon. I think it was about the 8th of June, reasonably soon after the relevant notice letter went out. So he has at least been in touch before this meeting, which is obviously an important meeting, kind of finalising the kind of identification of the parties. And I know that, Mr. Jimison, you've written down some thoughts. I'm just going to hand the floor to you to read out the statement, which has been shared with the acquiring authority very, very shortly before this meeting, and our intention is to upload after the meeting for others to see word for word what's being said. But this relates to the question as to whether his request to take part in these proceedings as an objector, non-statutory objector, should be allowed. And I'll make a ruling about that, but probably not in this meeting. I'd like to probably reflect on things. I'm going to hand the floor to Mr. Jimison just to make his statement and see what he wants to say in this regard. So the floor is yours.
Thank you very much, sir. Good morning, everybody. Written statement, as I say, it has been uploaded or sent in, so it will be there for you to reflect upon in due course. However, here I go. Worth saying, I'm not from a legal background, I'm not a lawyer, I'm not a solicitor, and I have no support in that regard. However, I am Kevin Jameson, and I live at Sunnyvale, Thornton Glen, Innerwick, EH42 1QT. I'm looking forward to making an ongoing contribution to this process over the coming months and to reaching a satisfactory conclusion, although I do note with some disappointment and surprise that the acquiring authority has objected to my involvement. My home lies within one of 20 small island sites, as I've termed them, created by a rather alarming red outline planning boundary that has been created around local dwellings. This fact alone has caused significant and unnecessary distress to myself and others that should be acknowledged and addressed. There are currently also a number of other questionably large and overlapping outline planning boundaries affecting the area where I live. I'm an enthusiastic member of the neighbourhood who passionately believes in community and all that it encompasses. It is worth stating clearly at this point that I, like many of our rural community, are not objecting to Berwick Bank Wind Farm. I and others fully support the decarbonisation of our energy generation processes and infrastructure. Simply put, we all get it. This, however, is not about the why. This is about the how. The context of my request to be involved in this thus far opaque development process is not therefore abject NIMBYism, as some of our group have been accused of by SSE personnel. It is not to spoil, to disrupt or to delay, but to simply make a difference, to reach the best answer. The reasons I object to this CPO process are relatively simple. The layout and configuration of the current individual CPO plots are clearly predicated on the assumption that the current form, alignment, layout, shape and scale of this proposed development is the correct one. I dispute this, and I am confident that alternative sites and routes can be demonstrated in due course. It is appropriate here to refer to the letter of objection to my involvement in this process, sent to your good self, sir, by Mr. Colin Hamilton of Gillespie McAndrew. Mr. Hamilton notes that the purpose of this inquiry is, and I quote, to inform the Scottish ministers so they can make a decision whether to confirm the order. The Scottish ministers can only logically make such a decision when the form, outline, shape, scale, impact, and mitigating actions of this development have truly and collaboratively been concluded and demonstrated as such. I contend that the consultation to date has been an utter sham, consisting of nothing more than a tick box minimum effort exercise by SSE. The Energy Minister, Gillian Martin, has recently written to our Community Council in relation to this project's consultation process, noting that, and I quote again, Scottish ministers also have an expectation that all parties should work together to coordinate development and minimise any impacts on communities and the environment. Where is the evidence that this has happened? This is a requirement under NPF 4 and associated guidance notes. My point here, sir, is that if the collaboration and consultation that the Scottish ministers clearly expect to happen was to properly happen, then the shape and scale of these areas subject to CPO notice at this very premature stage would look very different. It is not therefore practicable to separate the CPO and planning processes, as Mr. Hamilton conveniently and simplistically attempts to do, to exclude me from further involvement. These processes are inextricably linked. I live in a community already accommodating large and significant industries, facilities and infrastructure, each of which will have their own future needs for expansion, development, major maintenance, rehabilitation or change. Society now demands and deserves ever-increasing transparency, openness and accountability when such works are planned, and this project is no different. New and stretched benchmarks of engagement, support, acknowledgement, understanding, collaboration and respect should be agreed with communities affected by development. This has not been done. This is truly disappointing and surprising for a project of this scale and importance. Despite various previous assurances that developers are all working together, it is clear that they are not. There has yet to be presented a coherent and coordinated plan. The law, I understand, requires this. It is incumbent upon all developers to optimise and rationalise their proposals to ensure minimum land take is required and minimum disruption thereby results, most particularly when they do not even own the land in question. None of this can be demonstrated. Land is a precious commodity. It is increasingly valuable to those that own it and increasingly costly to those that want it. It is increasingly important in terms of food production. It is immeasurably important in terms of wildlife, human enjoyment, health and well-being. Key for those whose livelihoods depend upon it. Land is defined by so much more than a line on a map. It is one of the few things that we will never be able to replace. So I ask, is it unreasonable for me to be involved in shaping my community? My ask of this inquiry is simple. To rethink and refine these current proposals, to reset the ambition for neighbourhood engagement and collaboration, to respond to and meaningfully involve those affected, to resolve to rebalance the inequitable and unjust situation that has emerged in this small rural community by the purposeful exclusion of those most affected. Thank you, sir.
Thank you. Now, some of those issues we'll come on to just in the next agenda item 11, which I'm going to bring forward there. But I'll just bring in Mr. Hamilton on the question of what he's just heard and his letter objecting to Mr. Jimison being brought on board as a non-statutory objector.
Thank you, sir. And I'm grateful to Mr. Jameson for having provided a copy in advance of the written statement to the reporters unit and for that being asked to me this morning. I think I would simply say that I don't accept the criticisms of SSE or the acquiring authority as set forth in Mr. Jameson's statement. I don't propose to refer to them individually. Instead, I would propose to take as read my existing letter of the 20th of June. And if I can add two very brief points to that in light of the statement this morning. Firstly, it is clear from the Circular 6 of 2011 that it may not be possible for an authority to show with certainty what some or all of the land in the order is to be used for at the point the order is made. And secondly, I do maintain that Mr. Jameson's objections are based essentially on this being a planning inquiry, which it is not. And in my submission, this inquiry should not be used as a proxy for a planning inquiry.
Okay, thank you. I don't know if any other party wishes to say anything in relation to this question, or whether it's otherwise I may just comment further on this. I suppose one of my issues that comes to mind, Mr. Hamilton, is given, as things stand, there are 16 objections, so we can't tell what's going to happen the period ahead, but there's a likelihood this is going to go to an inquiry process. And you've seen what Mr. Jamieson he's had to say today, but you'll also have seen his communications with my office in the period up to now. Now he accepts he's not a landowner directly affected, but he's very closely affected. And he has an interest, but I think he understands that the planning is a different process from this. He's made his comment about the interaction between them. I guess my question for Mr. Hamilton is to what extent his participation would materially prejudice the position of the acquiring authority, given that there are 16 other objectors.
Thank you, sir. I don't think there would be material prejudice as such. I think my concern, as set out in the letter, is that Mr. Jameson's objections are not relevant because they relate to matters of national policy or are really matters for the planning authority to deal with. So while matters could be dealt with in the inquiry, it would just add to the burden already on the inquiry and the acquiring authority.
Okay, I'll say something more, then I'll give Mr. Jamieson final say on this issue, and I'll reflect on this later on. I mean, certainly in terms of the kind of expeditious use of time and resource in looking at the inquiry matters, I would certainly always be interested in people making representations on issues that are not otherwise covered by other parties. So there's a different angle to what's there, and it's relevant. Then there's some merit in hearing all of that. It's of less value, I think, to me, if an objection from somebody like Mr. Jamieson or indeed others in the area living there are simply endorsing objections made by others. Hearing something several times adds only a limited weight to hearing it once. But there is something to be said for hearing it in a different angle. So if he is permitted to participate, which I need to give some thought to, I'd certainly be looking for him not to be simply adding or endorsing what others are saying, but if there is a different angle, if there's something different that's appropriate for the inquiry, it would be important, I think, for everybody's sake and the efficient operating of the inquiry, for that to be limited to that. So that's a kind of a bit of a thought in terms of if permitted, how that would work. But I'll just give last word on this point to Mr. Jamieson, and as I say, we'll reflect. He can certainly happy to stay. I'm happy for him to stay for the rest of the meeting. I quite like him to stay for the rest of the meeting. But last word to Mr. Jamieson on this point.
Thank you very much, and thanks, Mr. Hamilton, for your comments. You've probably all guessed I'm new to this. I'm unfamiliar with it. I find it slightly daunting. That goes without saying. I will say all I'm trying to do is to make a difference to my community. A lot of these objectors are my neighbours. I know them. I know they're not all here today. They've sent their legal representatives. I feel I can bring a different angle. I would like to be heard, but sir, that is entirely your decision. But I would like you to kindly note my interest and involvement going forth. Thank you.
Thank you. Yeah, thank you for participating. I certainly, I hope this hasn't proved too daunting for you. I know it's not a particularly easy forum to participate in. We'll talk in a few minutes as to how we'll deal with oral procedure of whether we get together in a room, which may or may not be easier for you. So, but I do appreciate that surrounded by on student at least people with banks of lawyers is not always the easiest environment to participate. So thank you for your very clear indication of what you've said this morning. I want to move on because it's linked with this to the question about the question of general issues about prematurity, which has a number of angles. Because reading again in detail the statement of reasons, there are quite a lot of cross contingencies in this application, and as Mr. Jimison says, insofar as some of them are, if you like, to the preconditions, then the question has been raised by some parties as to whether proceeding with the compulsory purchase order at this stage is actually the wrong way around, and it should be dealt with. Matters should be dealt with in a different way. I would ask Mr. Hamilton to read all the other consents that he requires. You can see that from the statement of reasons. But I would actually welcome perhaps an update on some of them, and start with planning permission, because I think I've seen from some of the papers, and I've now slightly forgotten where I saw this, but the planning application to East Lothian Council has been made and is approaching, I think within the next month, is approaching the date by which they are obliged under the relevant statute to decide the planning application. I've read the statement of reasons, which sets out and echoes the test in the guidance, Scottish Government guidance, as to what the appropriate test for me is, that there's a reasonable prospect that planning will be granted. But it might be useful simply, if I'm right about the imminent decision date, just for an update of where we are and what we think the procedure and process is likely to be in relation to planning matters, Mr. Hamilton.
Yes, sir. In relation to the onshore planning application, which is for planning permission in principle, and the application, as you will have gathered, was validated in March 2023, which does mean that the 4-month period will shortly expire. However, it's not expected the decision will be made in that timescale. And there are ongoing discussions between the acquiring authority and the planning authority. And as I've already alluded to, the acquiring authority has committed to submitting additional information in relation to some aspects that the planning authority have requested information on, particularly the landscape officer and flood protection officer of the planning authority, and in relation to the cumulative impact assessment of the Brankston Energy Storage Facility, which is now before the Scottish Ministers also. I've indicated that's expected to be submitted in mid to late July. At present, the acquiring authority expects that there will be a committee date in September or October of this year. But of course, that is subject to the usual caveats, sir.
Yeah, that's obviously very useful, an indication as to when they're expecting to reach a decision. That may have an impact on the timings we look at in terms of oral procedure that we're going to come to very shortly, because obviously it's right that we can anticipate what the general local development plan context will be. But if we're at the stage where around September, October, we actually know what the position is, at least in terms of planning permission in principle, then knowing that before we get to a procedure for oral hearing would be quite relevant, and that's actually it's clearly important, because if the local planning authority makes a decision within that time frame, if it agrees planning permission in principle, then that it effectively goes quite a long way to remove any question of prematurity in relation to planning. But if it were to refuse, then that would flip around the other way around and would leave, obviously, your clients with the decision as to what they do next. They obviously have an appeal right to DPA. One of my fellow reporters may end up dealing with an appeal, but if there's a refusal, that changes that dynamics of the question of prematurity. So maybe for planning, it's a useful update, and thank you for that. It may well be that we take that into account when we look at the date for the hearing, for the inquiry that we come to the second. I'm going to go through all the various issues in my mind and then open up for discussion to other parties. The other is the Section 36 consent, and I know there's other various marine consents which I've described as under the Marine Scotland Act 2010, the Marine Coastal Access Act 2009. But again, maybe if you can give an indication as to the kind of state of play with those applications, that would be useful too.
Yes, sir. The Section 36 consent is the principal consent which relates to the construction and operation of the offshore wind farm. And as you've identified, there are also 3 marine licence applications, one for the generating station and 2 for the offshore transmission infrastructure. These were submitted in December of 2022. A request by the Scottish Ministers, or Marine Scotland on behalf of the Scottish Ministers, was made for additional environmental information on the 26th of May 2023, which has what has prompted the additional information I've already alluded to in the offshore application. The main focus of that additional information will be on responding to inquiries in relation to the derogation case, which is part of the offshore application. And at the moment, it is thought that the earliest determination date for that is going to be December of this year, although again, of course, that is subject to the usual caveats.
Yeah, in some ways, I'm going to open this up for discussion for others just in a moment, but in some ways, one of the issues that was in my mind that I saw from your response to the objectors is this issue of requiring a derogation. And I know you give examples in that, and I'm trying not to get into substantive detail here, and you indicate the derogations have been granted in other circumstances. But again, if the question before me in prematurity is whether there's a reasonable prospect that makes it worth proceeding with this bit of the process, the fact that you need a derogation kind of plays into that angle of the equation. The other consent needed, I think this is Alistair for EDS, was the Gas and Electricity Markets Authority consent. And maybe Alistair, I don't know if you want to speak about that, as to whether your clients maintain potential issue as to whether there's a consent required in that respect, and whether that also should be a ground to say it's actually a bit premature if there's issues arising in that context. It's Alistair.
Thank you, sir. I should say that EDF are one of the parties that are continuing their discussions with the acquiring authority and are making progress and hoping that at some stage they may be able to withdraw all their objections to the order. But for today's purposes, I have taken instructions, and so you may be slightly relieved to know that the issue in relation to whether it would be premature of you to consider the CPO order prior to resolving the issue of the consent from the Gas and Electricity Market Authority is no longer going to be insisted upon by EDF. It's a matter of the interaction between 2 electricity license holders having rights over the same land, but it is something that we now believe can be resolved without needing to worry yourself with that, sir. So that may make matters a bit easier, at least on that one issue.
Yes, I'm grateful for that. And you'll be relieved to hear that if that hadn't been the case, I was going to be imposing an obligation on you to explain in more detail within a deadline yet to be fixed why you thought the position was that, because it did strike me there was a potential issue there. But if that's not being insisted upon, then we can both be content in that respect. And my other specific issue, which I think from SPT and SPD, and possibly William Dunlop as well, is this question about the Brankton power station, the substation, And I think also there was some suggestion there's a separate planning application that was under consideration at some point, and the interrelationship between those matters. And again, I may bring in those agents who'd raised those points just for an update as to whether there's still an argument that this leads to prematurity of me conducting this bit of the examination. If anybody wants to comment. Mr. Carroll putting his speaker on.
I will comment. Firstly, cut brief. Those are all still issues. They all relate to prematurity, and they're all still insisted upon. The date about the determination, I think you got from the Dunlop's letter of objection of 20th of April. The one interesting thing I did note by looking at the Crystal Rig decision, which you directed parties to, is that for all of the consents that were required in that particular case, all of them had been obtained by the time the decision was reached in that case. I thought it was interesting to note that that was something that was already taken care of in that. And indeed, there was a finding in that respect, particularly in relation to that granting of the CPO. Page 4, Mr. Bryan said the necessary consents and licenses have been granted for the offshore wind farm for onshore works. I appreciate the test is a reasonable prospect of them. But obviously then we have heard that there is two major applications, both for planning onshore and for the Section 36 application are themselves subject to considerable delays. Normal delays as part of those particular processes, but certainly quite a bit in the future compared to when it is the acquiring authority is seeking to promote the CPO. Then going back to the final matter about the interrelationship between that and the Scottish Power Brankston Field substation, that matter has been raised at paragraph 7 of the letter of objection, and does raise a matter that there is potentially a conflict between those. And I anticipated that we set out our position quite clearly on that. There is a conflict. There is certainly an argument that that particular matter ought to be resolved first, because it will be impinged upon by the CPO if it is to proceed. But also I had expected that there would be some input from representatives of the other parties that you mentioned, SPT and SPD, with regard to that. But certainly from my own point of view, I think there are certainly very live issues around that which require to be resolved first.
Yeah, I wonder if I think Shipman Wedderburn and behalf of SPD and SPT, whether they want to contribute at this stage on that issue.
So similarly to a number of other parties on this call, SPT and SPD are in discussions with the acquiring authority, and good progress has been made, and the hope is that resolution and agreement satisfactory to all parties will be reached before we reach further procedures in this inquiry process, and that agreement will allow for any perceived conflict between the SP transmission and SP distribution projects and existing assets and the acquiring authorities projects to be resolved. And I should probably also mention, although parties might be aware, that there is a separate planning application for the Scottish Power project, the Brankston substation, which is before the local planning authority at the moment.
Do you have any sense as to when that's likely to be decided?
Not at this stage, but I'm happy to provide an update to the parties and yourself, sir, after this meeting.
Yeah, that might be useful. Just to have that. I mean, the issues and I've certainly seen the points in relation to the substation, and it was also, this echoes what Mr. Jimson's been saying to a certain extent, is that in the statement of reasons there's a reference. Let me try and get it up on screen. At paragraph 3.15, where it refers. I'll just try and get this for me, if you just bear with me a second. it refers to additional flexibility being required. And I can't quite recall what the context of that is, but a reference at the start of paragraph 3.15. Hold on 2 seconds. Reading from request. Additional flexibility is required at the connection point because the final corridor will depend on the final design of the SPT Braxton substation, which is not as yet known, and that's obviously consistent with what's being said. I suppose my sort of slight anxiety there is when
Sir, hands over on this point to Sarah Edwards, the consent team manager for the project.
of course. Thanks, Sarah.
Thank you, sir. Yes, we're, in terms of the process with regards to the scheduled monument consent, in engagement with East Lothian Council Archaeology Department in relation to this, and there's ongoing discussions around works and site investigations that need to be completed as part of those works. And there's a meeting still to be arranged with East Lothian Council, and that's part and parcel of this ongoing engagement that we're having with them on the planning application process. So it's all interlinked with the planning application.
I mean, it's clearly there's a complex interaction between a number of things. I've certainly heard the point about the challenging nature of the end point, and it's clearly sensible for all these matters to be progressed in sort of tandem with each other. It's not a linear process, and there's a clear understanding of different jurisdictions and different remits in different areas. I'm not really sensing, and I'll know to be corrected by those objectors on the call, I'm not really sensing a suggestion that I make a decision to throw this back and say, you know, we can make no progress in this, but rather we just need to be sensibly cognizant of the fact that some timescales, as Richard Carroll said, maybe not sort of unusual for timescales to slip. But they're longer than might be for other circumstances. So I'm unless anybody kind of has any takes a different view, I'm more inclined to treat this as a matter coming on maybe item 4 of the agenda, that we need to maybe just be a little bit cautious in terms of how far we go at this stage in looking at fixing kind of dates for the inquiry. And it may well be we have to come back for a further meeting once matters are clearer, perhaps in the early autumn, to be looking at this. So if that makes sense, I'd go on to item 4 and maybe talk less, I think, about looking for actual dates for the inquiry, because it feels to me as if we'll need to take a bit of a rain check in October to see where we are in all of these, perhaps later. But I think it would be useful still if I could just get a sense from parties. Again, I'll start with the acquiring authority, and it's going to be really hard. I found, thinking about this for this meeting, I found it very hard to work out how many days we might need. I mean, my kind of finger in the air thought was 3 days, but others may take different views in all of this. So I suppose for now, the question is really that I'd just like to get views from Mr. Hamilton. First of all, is the question as to whether this is appropriate for a hearing or a full public inquiry? For Mr. Jimison's benefit, a hearing is a kind of discussion, not unlike this actually in some ways, where the reporter, i.e. myself, kind of leads discussion on an agreed agenda and asks people for views and draws evidence, where I'm the lead, a kind of inquisitorial sort of examination. A full public inquiry is where witnesses lodge statements and are effectively led by the lawyers on behalf of the objectors, and you have the kind of examination, cross-examination and the like. And as a way of progressing things. So they're the two options about how we proceed. The next question of whether we do it virtually or whether we do this in person. And if we're doing this in person, and I'll look to Mr. Jimison for this as well, if we are going to be doing this in person, whether he could recommend today or at a later point an appropriate. I think there is a village hall in our website from my Googling. Whether there might be some capacity to be going and doing things locally. So as I say, I don't think we need to look at dates today, but I wonder if Mr. Hamilton wishes to express a view on those other questions, nature of the hearing and length, etc.
Thank you, sir. Well, my finger in here had been 3 days with a reserve day of 4, so I think we're quite aligned on that. In relation to how it's dealt with, I think it would probably benefit from dealing with things on a topic basis and then any site-specific issues. And in particular, my working list had been routing issues, agricultural issues, the lack of engagement and prematurity issues, and then the planning and needs case so far as relevant. And lastly, any technical points such as relationship of other consents. I would suggest that potentially all of those could be dealt with by written submission, but in particular the last two, I think, would benefit from written submission rather than oral procedure. If oral procedure is necessary, then yes, I would agree that hearing sessions would be the best way to proceed.
And certainly the more that can be agreed, the better in that sense in advance. So is that Mr. Jimison commenting?
No, sir, I
wasn't really commenting, no. No, it's okay. I think somebody was about to speak there just now.
So I was just about to add, sir, in relation to in person, yes, the inquiring authority's preference would be for in-person meetings. In relation to Berwick Village Hall, I think it would be a question of whether it can accommodate the numbers required. Mr. Jamieson may be able to assist us in that, but the other alternative the acquiring authority would put forward is the Bleaching Field Centre in Dunbar.
Okay, that's useful, thank you. Okay, can I just invite views from others? And Mr. Cornwell's first with a hand up, so we'll go there first.
Mr. Carroll here. The preference for the objectors, Dunlop objectors, is for there to be an inquiry rather than a hearing session for all matters. And I think the inquiry is something that would be, there are large matters of really quite some complexity, and I think they would be best served by an open forum and an inquiry session for that purpose. And I would suggest that would be the default position, as is normal in compulsory purchase inquiries. There may be exceptions to that. Obviously, hybrid operations are something that you'd be well familiar with. There may be certain matters that might be more appropriate to that, but I would urge upon you, sir, a default position that all matters should be aired in full in inquiry sessions, and moreover in person. I share the view that it would be best done in person. I think that would be more fruitful and easier to thrash out matters and without any risk of technical difficulties. Now, in relation to duration, I myself conducted an inquiry for a compulsory purchase application last year. We ended up with 2 objectors, not 16 as we have here. and that required 3 to 4 days. So I think it's hopelessly optimistic to say that it's going to be something that will take 3, maybe 4 days. I totally disagree with that. And I might add, sir, that in terms of the evidence that I've discussed with my instructing solicitors that we would wish to lead, that might well itself take somewhere in the region of 2 to 3 days alone for the matters that we wish to raise on the agricultural issues that are raised. I can expand upon the particular witnesses I have in mind, but I think that might be a bit early to say that now, because of what you've just said about a rain check. But certainly, I think 16 objectives, even if it whittles down by even 2/3, we're still looking at something in a number of weeks, not a number of days.
Yeah, thank you. Well, that's the reason these calls are useful, to get different views. Okay, round table, and Alistair.
Thank you, sir. And at the outset, I just reiterate what you're thinking about, sir. If the outcome of the onshore planning application is not going to be known until October, I would suggest that any inquiry or hearing session be held sometime after that, given that that is clearly going to have a strong implication on the prematurity arguments and may be determinative one way or another of how matters progress. Insofar as EDF's objections are concerned, as I say, there are ongoing discussions. There were 4 headings of objection. We've now withdrawn the GEMA consent objection on the basis that that can be discussed in a different forum, and we had already withdrawn the objection in relation to the period of objection. So all that remains are that the prematurity arguments, which I think could either be resolved by what happens in relation to the planning applications or could be dealt with by written submissions. But the final heading of objections by EDF relate to potential impact on the operation of Torness. And insofar as those are still in existence at the time that you are proposing hearings, EDF's preference for that would be to have a hearing session in person, to have a collaborative discussion and to hopefully help you understand the issues that may arise between the operation of the 2 electricity generating facilities. And I imagine that could be just 1 day of a hearing, hopefully, on that specific issue, and have no particular view on how other matters might be dealt with in terms of procedure. But that would be my suggestion, sir, that matters be postponed until after October, and at least a month or so after that at the earliest, so parties are able to formulate their positions in the knowledge of what is happening with the onshore planning permission. And that would also give parties further opportunity to perhaps narrow down or come to an agreement that alleviates the concerns that are still at issue at the moment.
Okay, thank you. That's very helpful. I'll now bring in Alana, then Fraser.
Yeah, I just wanted to pick up and say I think Tarmac as well would also suggest that an inquiry in person would be the most appropriate here, given the complexity of the issues. So, yeah.
Okay, thank you. Then Fraser, then Scott.
Thank you, sir. My comments are really just to indicate how I suspect the evidence may narrow down slightly over time insofar as my clients, the Nuclear Liabilities Fund, are concerned. And what I mean by that is that we have an interest which is broadly aligned with that of EDF that Mr. Burnett has just spoken to. So if there were to be a hearing session which does deal with the operation of the generating station, we would wish to be there, but the evidence that we would lead would be supplemental to that of EDF, so it would not be coming fresh from an entirely different direction. So I suppose ultimately my submission on the point would be, I think that an in-person hearing would be sufficient, well, would be preferable, and I think 1 day would be sufficient to get through that evidence as well. And I also think from where we sit at the moment, the Nuclear Liabilities Fund would not have much, if any, interest in the other sessions that would be taking place, so such as those described by Mr. O'Carroll. And finally, and I suppose this should have perhaps been my first point, is that in terms of the prematurity point, which we do rely on as well, that it does appear that timetabling may resolve that for the piece, and we would certainly be content with it being dealt with in that manner, in the sense that we wait and see what happens around October time when the applications are determined.
Okay, thank you. And I certainly take those last 2 points, that the scheduling idea of ensuring that we allocate certain times, maybe along the lines of what Colin Hamilton has said, allows people to attend only for their interests rather than unnecessarily attending for longer periods. So thank you for that. I now bring in Scotland, Peter.
Thank you, sir. So to note that both the acquiring authority and we're expressed a willingness to enter into discussions, as for a number of other objectors, to seek some form of a certification agreement that may resolve some or all of our concerns in due course. So we support on that basis a later process, whether that be inquiry or hearing, to November or December, to give that opportunity for those discussions to be progressed and hopefully come to a satisfactory outcome. The only other point, sir, was to note that in terms of process, I don't think that we do this inquiry or hearing process, but I suspect process which hearing process would be sufficient to go over the impacts specifically on the non-art property interests and the set protection issues that we have. And I would anticipate that a day's hearing would be sufficient for that. I'm not sure where that fits in to Mr. Hamilton's headings. I'm assuming that perhaps the specific impacts on what one particular land interest comes under Mr. Hamilton's broad agricultural heading. Just to clarify that, and as you suggest, sir, the idea of having separate sessions for different interests, I think makes a lot of sense. Thank you, sir.
Okay, thank you. And Peter?
Thank you, sir. My clients would support an in-person session and topic a approach to the session so that their involvement is their particular concern. And given the nature of my client's concern, I think that a half-day hearing session would be appropriate in the narrow scope of the effect.
Okay, thank you. And Magda's got a hand up now.
On behalf of SP transmission and SP distribution, I agree with what parties have said, that an in-person session would be preferable to discuss matters if it's needed. And similarly to NNG and others on this call, we're hopeful that resolution can be found before sessions are held. But in the hopefully unlikely event that we are participating in the sessions, we would suggest that a hearing would be most appropriate to discuss some of the technical issues in a collaborative manner.
Okay, thank you. Anybody else? No one else has got that hand up. But I don't know if anybody else wants to speak. Somebody was coming in there.
Yeah, sorry. Just Lewis Crofts for the Ainsleys. Like a lot of the other parties, our clients are at quite advanced stages of negotiations with the acquiring authority. So we'd hope, not to really have to be in the position to go forward for much longer. But our preference would probably be for an in-person hearing. A lot of our objections are kind of possibly within the scope of the agri heading that Mr. Hamilton brought up earlier. So we wouldn't expect to be leading any evidence for more than a day or so on that respect.
Okay, thank you. Anybody else? Yeah, thank you. That seems a fairly clear preference, certainly, for doing this in person, which I understand, and I'm grateful for the suggestions of options that I can ask should be explored. I suspect in terms of the format, we'll need to make a judgment a little bit later, and we may end up looking at this again on a topic-based approach as to what might be appropriate for a PLI and what might be appropriate for a hearing. I've got a hearing winning 7-2 in terms of representations made today, but I appreciate, as I say, there can be a nuance as to part hearing and part of PLI in taking that forward. So that's all very useful and helpful, and thank you to parties for all of that. Item 6 in the agenda, item 5 in the agenda is whether there's any special arrangements that may be needed to support participation, and this might be particularly if we are, I mean, if we're holding whether a hearing or whether a PLI in person, whether anybody either themselves or witnesses anticipates having anybody who might have a special need, whether for hearing or disability, mobility or whatever. So if you just keep us informed, you might not know now, but if that emerges once witness lists get worked out, obviously DPA will accommodate that as far as we possibly can. So just let us know if there's anything particular of any special arrangements that might be needed to support as active and full participation by parties and objectors and witnesses as needs be. Item 6 relates to the production of documents and preconditions. Again, I think that, apart from recognising that that's obviously we will want that and need that. I'm quite flexible as to what deadlines are relevant for production of documents. It might depend as we get closer to the inquiry and hearing dates, how much notice is given, and when in advance of the hearing they would require to be lodged. I tend to look at 21 days ahead of process, but again, maybe that's something that in light of the discussion as it's developed today, it's a bit premature to reach views on that at this stage. If anybody had any strong feelings they want to express just now, then feel free to do so. But in terms of fair notice, we'll obviously look to be setting a schedule once we get closer to finalising hearing dates. Then we can set that out. I should say that my own personal practice for matters that I deal with, whether hearing or PLIs, is that I don't tend to look for closing submissions at the end of the process. I tend to prefer to give parties a period, maybe 7 days, to be agreed after the end of the process, so that those counsel or solicitors you should note. I say that's just what I remember just now, rather than scurrying about trying to get closing submissions at the end of a hearing. My own preference is to give you a little bit of time to submit closing submissions, just on the kind of the usual basis. But again, maybe we can't progress that issue too much at this stage. But again, I'll look around to see if anybody wishes to contribute or has a hand up on that particular angle. Yes.
Perhaps I can comment for the acquiring authority.
Yes, of course.
I would reiterate that it is the acquiring authority's strong preference to proceed on the basis there's a reasonable prospect of the necessary consents being obtained. And of course, if there was to be a delay from September or October dates, as can occur in certain circumstances, that we would then be into a further delay to this process. So it remains my position that the appropriate balance to be struck would be an inquiry date at the end of October, perhaps even as late as the 30th of October. But just in relation to the lead up to that, if I can set out my view on a framework that might be adopted so that parties can consider that in due course. It might be useful to have both rebuttal precognitions as well as precognitions. And in that case, it might be that 2 weeks before any session, there were rebuttal precognitions, and then 4 weeks beforehand, there were the precognitions and summaries, or in the case of hearing sessions, hearing statements. In relation to documents, that might be 6 or 8 weeks beforehand. But I think it would be important in the acquiring authority's view for those documents to include any technical or expert reports so that it's clear what evidence is going to be led And that will inform the recognitions and hearing statements as necessary. So I just want to outline that as a framework for discussion, sir.
Okay. So I would open that up for discussion. I mean, the one thing that strikes me is for those relatively longer periods, particularly for documents, linked with the idea of still proceeding with an end of October date, does mean 8 weeks from the end of October is not actually far away from now, in terms of expecting technical documents to be lodged and recognitions to be prepared. I'm not kind of sensing that's the kind of the mood of quite where we are in terms of preparation. But again, I'll open it up to others for comment before thinking further about that. Not seeing any hands up. It looks like Alistair's hovering over his mouse as if he's thinking about wanting to speak, but I don't know if you are or not. Yes, you are.
Yes, sir, I would agree that that would be quite short-term frame, considering the likely benefit of having a hearing in October. It could be, if permission is refused, that the whole project is put on hold, or something significant could happen, which would mean that significant work and costs would have been incurred for no reason. And I really do think waiting to see if progress is made on the onshore permission before progressing to significant expense and technical reports would be the way to go. And it's not really pardon for me to say, but I do believe that the derogation point is a significant matter that makes it difficult for the acquiring authority to be as certain as they might that they will gain permission. So this is not as straightforward a case as others might be in that respect.
Okay, thank you. Any other comments?
Yes,
Morris?
sir. I think, again, just to keep matters simple, and again, chiming with what's just been said, to avoid unnecessary expenditure and effort, that the classic timetable is 2 weeks prior to the first day that recognitions are lodged, and that's what you've stated in your correspondence, sir. And that classically you have 4 weeks prior to that would be when all documentation is lodged. And I agree that if you set a period further to a notional start date of an inquiry, we're really getting upon that very, very soon when there are so many ponderables. Not only the consents that I've outlined, but of course there is that derogation matter as well, which is another feature.
Any other comments? It does feel to me as if that's the combination of all these things makes aiming at a date at the end of October and fixing deadlines of that nature a little bit ambitious, I have to say, in terms of the uncertainties that are arising. I mean, there's obviously a desire to make progress, and the acquiring authority doesn't actually expect progress to be made, but at the same time, these are all complex processes. There are super numerous consents, and they all need to be secured before this project can proceed. And so there is a limited advantage in accelerating too fast on one angle, not least because we don't necessarily know all the answers, as Mr. Jimison has pointed out. But there's also, a relatively limited advantage in terms of what I can report on. I don't think I can make a recommendation, if I'm persuaded, of a conditional CPO. You either have to recommend a CPO or there's not. So I do incline to agree with Alistair and Morris that perhaps that's a little bit early for dates. But the idea of that time framework of the document, dates and perhaps even rebuttal of recognitions, I wouldn't be against that, setting the deadline relative to a date, even if the actual date of the inquiry is as yet unknown. So I can take that forward and then try to plan things around whatever. I think it is looking increasingly like we're going to have to have further meeting once things are clearer, which might indeed be around October to work that through. So again, helpful, and thank you all for comments for that. that just now. Now, I'm conscious that meetings of this nature can be tiring and can sometimes be lengthy. I'm conscious it's been going for an hour and a half. I don't think there's actually a massive amount more that we need to cover in this meeting, and I'm happy to press on to conclusion. But if anybody wants a comfort break or any a 10-minute stop just now, I'm very happy to have that if you prefer. If anybody don't feel coy about suggesting it if you do want that. But as I said, I don't think we've got a huge amount further to address in terms of today's meeting. And again, nobody is giving any obvious indication that they would want to take a break. I'm happy to kind of press on meantime with that. The next item on the agenda is item 6, and this is just the question of alternative routes. This is Rule 6 of the 1998 rules, and the relevance of this is it's not directly related to the question of whether, as some people have argued, there's an excessive land take, or indeed there's any other potential of routes or alternatives within the scope of the CPO as things stand at present. What Rule 6 is about is the question of whether the alternative site and alternative routes that any objector might consider should be properly explored in this process, where that relates to land either occupied or owned by somebody who's not already in this process. And that's a fair notice to them to make sure that if we're going to start talking about an alternative route that impacts on someone who knows nothing of this yet, then at the earliest stage possible, it's imperative, and Rule 6 underpins this, that we identify the possibility that may be something that we ought to be considering. No one has given me notice of any issues or any suggestions of an alternative that I should be exploring that involves the rights of others not yet involved. And again, I just want to double check whether anybody whether that is the position, whether I'm right in that assumption up until now, and whether parties may still contemplate the possibility of bringing someone else in, and a suggestion as part of their objection that land be utilised where no notice has been given. And again, I'll look round to see if anybody wants to put their hand up or speak on that topic.
There is an alternative suggestion in the Dunlop's objection letter, which is given a description, and it is the Dunbar landfill site, Oxwell Mains, Dunbar, and the postcode is given at EH421SW.
Yeah.
I know that Mr. Hamilton has been in touch with my instructing solicitor about this. I'm not currently aware as whether or not the occupants or owners of that site are or are not part of this process. But in any event, there will be. I suspect that the postcode and location having been given is compliant with Rule 6. But the one thing that's outstanding is whether or not there is, as you say, sir, somebody who's not part of this process who would otherwise be affected by that land take if it were to be an alternative taken up. And that's something that will be explored, and an answer will be given to Mr. Hamilton very soon.
Okay, well that's very useful, and if clarity on that can be given, and if there is any question of someone who is not part of the process already who ought to be brought into that process, then the sooner we know that, the better, to let them play catch up effectively, and make such representations as they think fit in relation to their land. So if I could leave you and your clients and Mr. Hamilton to continue that discussion as quickly as you can. Obviously, in fairness to any landowner who may want to participate, the sooner they're formally told and advised of this process, the better.
Yes, sir. If I could comment on behalf of the acquiring authority, and thank you to Mr. O'Carroll, he's correctly recorded there have been discussions. It would be of benefit to the acquiring authority to have a plan or map which identifies the alternative site, so that we can check precisely who the owners are, and also if there are any knock-on effects of that in relation to the route, for example, because the alternative site promoted by Mr. O'Carroll's clients is off route at the moment. So what a position would be in relation to an alternative route. There are also a number of other objectors, in particularly Crichton and Taylors and Tarmac Cement and Lime Limited, who said that there should be an alternative site or route, but no specification was given of what that should be. So if that is to be maintained as a position, I would ask that that is given to the acquiring authority as soon as possible, and perhaps within the next couple of weeks.
Yeah, absolutely. The sooner the better, certainly. I mean, I take the point that the postcode was identified, but it's something I'd like to be clear about as soon as I reasonably can for all those areas of land, so that we can get a proper framework as to who has an interest in this and who needs to be intimated, and the implications considered, so that that can be properly assessed and their property rights fully had regard to.
Yes, sir.
Okay, thank you. And Rona, sorry, beg your pardon, Rona.
Sorry, Kevin.
I just you popped up with your hand up, but you're not Rona, you're Kevin.
Apologies. Yes, regarding the thoughts on alternatives, I'm sure there's a lot of people have a lot of different ideas about that. One of the things that has never, I feel, been made particularly clear, because the community and others weren't understandably involved in optioneering exercises that the acquiring authority carried out, is that the alternatives, there is no visibility of the alternatives that have been yet considered. So alternatives that are now being promoted or suggested are perhaps just people's ideas. And I wonder whether or not it would be fairer or more reasonable to have sight of options that have been excluded by the acquiring authority, is a thought.
Yeah, great, thank you. Mr. Hamilton may want to comment on that. I mean, there is something in your statement to reason. This is what we're looking at, is a very technical angle of the alternatives, but you might want to talk. I think you have something in your statement of reasons, but you might be able to expand a bit on it, on the question of looking at the alternatives, and in particular the alternatives that, for the purposes of my remit, involve the minimum reasonable intrusion on private rights.
Okay.
If Mr. Hamilton wants to say something about that, or whether he wants to rest with a statement of reasons.
Yes, sir. Two things. Firstly, in the statement of reasons, I would draw the attention through you of Mr. Jameson to Chapter 4 in the statement of reasons, which deals with the alternatives, and there is I think paragraph 4.33 figure which shows the main alternatives that were considered. And there also in the environmental impact assessment lodged with the planning permission, I believe Chapter 4 goes into detail on the alternatives of that as well. I should also have indicated that if the alternative put forward by Mr. Carroll's clients is where we understand it is, it will not be a party who's currently represented or indeed a party to the order at present.
Okay, thank you. Okay, right. My next item on the agenda was arranged for a site visit. Now, it may well be that in light of what parties are saying, a site visit might be seen to be a bit premature at this stage as well. I'm certainly happy to look to identify a date at some point, and maybe in August, if it's thought to be of any benefit for me at this stage to be looking at a site visit. And that obviously, doesn't usually, although it can involve lawyers involved in this. But again, I suppose my question primarily to Mr. Hamilton is whether at this stage an issue of the site visit should be explored, or whether we should put that a bit on hold. Meantime, the issues around site visits obviously involve things that access private land, and any objectors who wish to identify particular angles, viewpoints and sites that I would benefit from seeing. All parties are entitled to attend the site visit, but some may have a greater interest than others and might want to point things out. As I say, the responsibility for any particular objector, if they're asking me to go onto private land, is to make their own arrangements to ensure necessary consents to me and all other participants for taking access onto private land. But before, again, talking about this in too much detail, I'll go first to the acquiring authority and then open to others as to whether we think we should try to arrange a site visit just now, or whether that too is something maybe should be left to a later date.
Thank you, sir. It may not come as a surprise that I would suggest an early site visit. If nothing else, to take advantage of the better weather we should experience. I'm certainly happy to circulate, and we've begun to think about potential viewpoints. I can circulate among other parties a draft plan which they can comment on with a view to agreeing where it might be helpful for you, sir, to visit. And then if there are differences, that can be noted also. SSE has also undertaken a risk assessment in relation to its own role, and we're happy to share a version of that in relation to any safety issues that we foresee.
Yeah, that's right. Before I opened it up to others, actually, I know I've noted the desirability of an early site visit. I was checking my calendar, and I'd identified as a possible date the 21st of August. That's a Monday 21st of August at maybe 11 a.m. Although obviously flexible at the timings. That gives us about 7 weeks. And again, I'm mindful that some of us are hoping to go on holiday pretty soon. But that was the sort of date that on a preliminary basis came to my mind, although obviously other dates are available. But again, I just may open up to others whose clients may wish to facilitate or participate in a site visit to see what their thoughts are on both what I've suggested, but also what Mr. Hamilton has indicated as well. I'll go first, Alistair, with his hand up. And then
thank you, sir. In terms of a date for the visit, I think that's a matter for you, having regard to what further procedure might be happening when. It's more just putting down a flag in relation to the other part of this agenda item about issues over access to private land, and to inquire what you might be envisaging at this point, given that you may not be surprised or perhaps relieved to know that access into the nuclear power station is not necessarily straightforward. And if you envisaged going into the nuclear power station, that might be something that would have to be considered very carefully.
That was not on my mind. I'm grateful for the invitation.
For my part, sir, unless and until the impact on the power station remains a live issue, I don't think that would be necessary. And obviously it'd be easier to organise access onto the land outside the power station. And if at any point you do feel you need to understand the workings, that could be a separate site visit at a separate time, and we'd have to have discussions about whether that would be open to everyone or not. So I just flag that as an issue for you to consider, sir.
Thank you. I wasn't at this, but I think I have visited the power station Torness before, actually, at some point in the past on the tours they do there. But no, I wasn't. I have to confess, I wasn't. I did not have in my mind going to anything that would require me to have any special arrangements to see any particular part of it. So, Alana, then Morris.
Thanks, sir. Yes, if you were minded to visit also the tarmac site, then we would suggest that you would maybe want to come before a blast, so you get a better understanding of the kind of complexity on site. And we would be able to say when the blasting operations occur. It could be, I think it was around about once a month. But also tarmac would need a bit of advanced warning as well of that site visit, just so they can put in place kind of health and safety requirements and things.
Absolutely. Yeah. Always in favour of health and safety requirements. Thank you. And Morris?
Thank you. As you'll appreciate, the Dunlop farm is some 1,000 acres. So the site inspection of that entire farm, which I think you do require to see, would probably take a full day. Now, that is something that can be accommodated with approximately 2 weeks advance notice. My suggestion would be that given the level of commitment you'd require for that inspection, something perhaps you'd want to do once only and would be best done after the evidence was heard. I've been told that in any event that the Dunlop's preference would be that such a site inspection, if it were to occur, would be best done in November, December or January of next year. So if you work around that, but in any event though, it would take that long, but 2 weeks advance notice would be required, and obviously all arrangements for access to private land would be made.
Okay, thank you. And Giles?
Yes, I would like to echo the sentiments there made by Mr. O'Carroll. The Moffat family would expect you to be interested in seeing their farming operation in the widest sense, so they would very much wish to be party to any site inspection. Again, there would need to be a little bit of lead-in time, and I would have thought 2 weeks would have been ample to make arrangements to make it safe and make access readily available.
Okay, anybody else? Any other hands up just now? I'm not sure, Giles, if that means that if we did, for example, I mean, subject to Tarmac's offer in relation to blasting and separating out the position as far as the Dunlops are concerned, whether it might be possible, Giles, to be looking at your client's site on a date, say 21st August, so that I went on site then and went to the Dunlop site in accordance with the timescale just described, and maybe separately to Tarmac. Would you think at this stage, I mean, you may not be able to say with certainty, that doing this as all part of a general site visit and then doing the two specifics afterwards could all work, could all be done in one day as apart from the two cases identified?
In the case of the specific issues that other parties have raised, we have no express suggestions as to when would be the right time to do it. It's more a case of just notice prior to. So I cannot think of any specific reason why your proposed date couldn't work.
Yeah. Although clearly, if it does, if you go back to respective clients and there's some reason, obviously, I didn't give notice of the date because I haven't been working through that level of detail, obviously, for all of you. If that date ends up not being one that works, then please, obviously, just shout. But I wonder if subject to the two observations made in relation to what circumstances might impact on dates and being delayed, could I leave with Mr. Hamilton then and take up his offer of suggesting potential viewpoints and then looking, as I say, penciling in the 21st of August. It might be better to go earlier than 11 a.m. if there's a lot to be seen, even on Mr. Johnston's client's land. But if I could ask that be pursued as options, and other parties note that as a kind of as a working date to work towards, and we can work out the detail of that and give appropriate notice and finalise that in due course. Okay. Getting there, nearly at the end there. My item 9 on the agenda was actually just to flag up. We've alluded already to the decision by Reporter Brian at the other NNG site at Crystal Rig. I don't want to get it because it is at the risk of getting too much into detail of what we need to be looking at. But it's just to give notice to the acquiring authority that one of the things I will be wanting to look at is the justification of the use of CPO powers, in particular in relation to kind of what otherwise might be looked at as being a kind of a way leave option. Now, I'm conscious in the statement of reasons they've set a little bit of that out, but just to give notice to Mr. Hamilton that at the hearing or public inquiry when it comes to something I'll be interested in exploring a little bit further. And really looking at that just on from the perspective that the obligation for me is to look, I think, to the least intrusive proposals impacting to the least reasonable degree on peaceful possession of private property, and the use of CPO powers as opposed to a way leave, and how that interrelationship works. And I say that because, as some of you know, in my role, I end up doing quite a number of way leave objections by licence holders under the Electricity Act. I'm conscious it's relatively rare to use a CPO. In fact, the case of Crystal Rig was the only example that I was aware of. So it's just really just saying so that the acquiring authority are aware that that's something I'd like to explore when we get to the process, in just testing that question as to the degree to which this is might be seen as an unduly intrusive way of proceeding. But I'll say I think no more than that just now, other than just to put that on the record. Item 10 was notice of the order, and there were some suggestions that because of the Easter period there was inadequacy of the formal notice of the order. I don't know if any party consider that I should make some sort of ruling in relation to the continuation of this process in light of any concerns along those lines, or whether the respective presence of parties here indicates that any prejudice that might have been suffered because of the service of the notice over the Easter period has now been cured. But again, any objector who wishes to comment on that as to whether there's any continued issue on the duration given for an objection period, please say. Is that Alistair? Nope.
No, the EDF withdrew that.
Yeah, I've seen that from your point of view. Just your name flashed up on my screen. I thought you're close of sticking your hand up, but no, that's all fine. Yes, I've noted that. Thank you. Thank you. Any others? Okay, that's fine. Item 12 on the agenda, since we dealt with item 11 earlier, and that's just again a flag up. I noticed that this goes back to the question of the remit, and it just again, and I invite parties to make any comments as they think fit, but it's just a flagging up at this stage that in addition to the interrelationship with other processes, there are certain aspects relating to national policies and to questions of compensation that are out with my remit. There are certain interactions, especially of national policies. The line between the two can sometimes be a little bit unclear, and there can be issues of relevance to me. But just to remind parties that there are certain restrictions on the things I can report on, in particular in relation to matters of compensation, and I would just encourage parties to bear that in mind in order that we can use our time at the inquiry and the process as efficiently as we possibly can. And my last point is just again a flag up there. Item 13 is just to remind parties that one of the options I have, if otherwise minded to recommend approval, that there is scope to recommend modifications to the order, and again that's something I'd like to explore, and that when we get to the stage of a hearing or a PLI, if there are suggestions that are made that in order to minimise the intrusion on private land, that modifications of the order are relevant, then it would be useful that the parties are prepared to address me on those issues so that I can fully and properly consider them. So just to remind, as if anybody needs reminded, I suspect for most people on this call, that I do have the power to make the recommendation involving a modification to the order. It's not just a kind of take it or leave it approach to that. So they were the only points, or all the points that I had for this call. I will come back to Kevin on the question if he's interested in this. I will prepare a short note of the meeting, and I'll circulate that for comments as soon as I can. But just before we close, is there anything anybody else wants to say? Again, I'll start with the acquiring authority, just that might have been missed or that we need to address or think about either today or in the period immediately ahead. So Mr. Hamilton first.
No, thank you, sir. That's been very comprehensive. No further comments from us.
Okay, thank you. And then round the room again, if you stick your hand up, if you wanted to say anything further at this point. And Kevin?
Thank you, sir. Forgive me if I've interjecting at the wrong time with this. Perhaps a little bit. We should have said it earlier. And perhaps there's too much detail. But if I could just aid my understanding on something here, please. There is a plot that is termed 16A as land to be acquired. I understand that in layperson speak that because it's to be acquired, there's going to be a big building on it. There is also a plot 25D, which is fairly close to where I live. That is termed for CPO for cable rights. We did, however, discuss Branxton substation, which is a thing that I am concerned about. I'm actually unclear on who's going to deliver that, whether it's SPT or SPD or SSE. But what confuses me somewhat is plot 25D would appear to be CPO'd, or if that's the correct term. But is it SSE Renewables CPOing it on behalf of somebody else to build Branxton substation? Because it doesn't all quite tally up in my mind. But if I could perhaps just leave that with you. Again, apologies if that's too much detail, but I thought I'd part with that.
No, thank you for that. I mean, I don't know the answer to that question. It may be that someone from the acquiring authority around the table can answer it, or it's possible that that's something that could be addressed offline to give you an answer to those questions for clarification of that.
So if I can indicate, I'd be happy to write to Mr. Jameson on that and send a copy of that to your case officer.
That'd be useful. I don't know, Mr. Jameson, I'm not sure we've asked you yet for your consent for your email address to be shared with the applicants, or whether you'd rather it just goes through our office. I'm happy either way, but we always redact email addresses and other personal details unless people are agreeable that these details are given directly. So I'm very happy if you're happy that Mr. Hamilton communicates with you direct, we can give them ensure that they have your email details if you're content with that.
I'm more than happy for anybody to contact me. Thank you.
Thank you. Okay, anybody else? Okay, I'm not seeing any other hands up, either virtual or literal, on the screen in front of me, though I'm conscious I'm not being able to view answer to everybody. So thank you all again for your participation this morning. It's been immensely helpful from my perspective. And as I say, I'll write up a note of the meeting and circulate that. And we can take next steps from here. Sounds like we might need to get together for a further pre-inquiry meeting sometime in the autumn, but we'll take a rain check on that in the meantime. So thank you again all for your participation, and I just formally close the meeting just now. Thanks again.
Thank you.